Back live now to the Hart Center office building for day number 3 of the confirmation hearing for Judge Neil Gorsuch. The committee should be gaveling back into session soon. Live coverage here on C-SPAN 3.
Thank you. Senator Lee. Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge. I want to begin by making a broad point, a point that relates to some of the discussions we've had so far in this hearing. A number of my colleagues in recent weeks have expressed concern, understandably, with maintaining the reputation of the federal judiciary. It's good reason that we do this. We, in fact, are the Judiciary Committee. It's our job, among other things, to exercise a degree of oversight over the federal judiciary, to make sure it's working well, to make sure that the laws and the personnel that we have in place are up to the task of deciding cases and controversies in the federal court system. I'll be the first to acknowledge I don't love every outcome and every case that comes before the federal judiciary. In some cases, decisions made in federal courts are frustrating to me. In some cases, I disagree with them, sometimes strongly. And yet, as a lawyer, as a citizen, as one who's interested in these sorts of things, I can say with confidence that I'd stack the federal judiciary up against any system of its kind anywhere in the world. And I can say with absolute confidence, this is the best there is. It's imperfect because human beings, by their nature, are imperfect. But it's really, really good. It's one of the reasons why it's important for us to defend the integrity of the federal judiciary, even while sometimes disagreeing with the outcome of a particular case. It's one of the reasons why many of my colleagues, along with many Americans, expressed concern when the President of the United States referred to a judge who issued a ruling he didn't like as a so-called judge. It was understandable why some people were concerned about that. It's not a statement I would make, in part because I think it's important to uphold the federal judiciary as a system that is good, notwithstanding its imperfections. And yet I find it interesting, ironic, and quite troubling that many of the same people who were the first and the loudest to complain about what the President of the United States said in referring to a so-called judge have been some of the first to denigrate the federal judiciary. I don't just mean criticizing a particular decision or a particular judicial philosophy. I mean referring to the Supreme Court of the United States as an organ of the Republican Party. This is wrong. This is not the kind of statement that should ever flow from the mouth of a United States senator, from a member of the Judiciary Committee, from a citizen who loves this country and wants to make sure that our federal judiciary remains an institution that is revered and respected, although its decisions might from time to time be less than perfect. There is no good reason to make a comment like this. Now, I also find it interesting that in the first 2 days of this hearing alone, we have seen the independence of Judge Gorsuch attacked no fewer than 27 times. We've seen the independence of the Supreme Court of the United States and of the federal judiciary called into question no fewer than 17 times. Those are stats from the first 2 days alone. Those statistics do not reflect statements made today. One could argue that those statistics may well have doubled by today. They have certainly increased substantially. And I find that troubling. I certainly find that something that we ought not be aspiring to. What we ought to be aspiring to is talking about how we can improve the federal judiciary, talking about the highest ideals of our system. That doesn't mean we all have to express agreement, not with this nominee or any opinions that this nominee may have written, or even this nominee's judicial philosophy. But it does, I think, mean that we ought to identify disagreement as disagreement, genuine disagreement when we see it, rather than impugning the character of individual jurists or the credibility of the federal judiciary as a whole. I think the American people have been asked time and time again to settle for this. I don't think it's time for them to settle. I think it's time for them to expect more. I think it's time for the American people and for the United States Senate to expect more of us, of this committee, of this body, when we speak of the federal judiciary. And that means not referring to it as an organ of the Republican Party, the Democratic Party, or any other political enterprise, or anything else for that matter. We have an independent federal judiciary, and it needs to be respected as such. A lot of this conversation is somewhat ironic in the sense that a lot of the criticism against the federal judiciary is perhaps, I wonder, a bit misguided. It's true that we should all be concerned about the excessive accumulation of power in the hands of the few. There was no concern that weighed more heavily upon the founding generation, upon the founding fathers as they convened in Philadelphia in that hot, fateful summer of 1787. They were concerned about what would happen if too much power were accumulated in the hands of the few. And so they put together a system that was designed to diffuse that power, to spread it out, to make sure that no one person and no one group of people could accumulate too much power. What we've seen over recent decades is power reaccumulating. One way of putting it is that power has been taken away from the American people in two steps. First, as it's been moved from the American people at the state and local level to Washington. Within Washington, as it's been handed over, in many instances voluntarily relinquished by the people's elected lawmakers to unelected, unaccountable bureaucrats. In some instances, it's effectively handed over to the judiciary, although this is a little bit less common. We've seen that in some instances, as in some of the statutory frameworks that we've discussed today, where Congress will come up with an impossibly broad, non-judicially manageable statutory standard, and then we just expect the courts to figure it out, complaining about it when we don't like the results. In any event, this power has been taken away from the people in these two steps, from the people to Washington, from the people's elected representatives in Washington, whose job it is to make law, whose only job it is to make law, over to those who are unelected and unaccountable. It is, I believe, no coincidence that during exactly that same time period, the last 70 or 80 years, I would say, and by the way, I would add to that, that this has been done under the leadership of both political parties. It's been done under Congresses, Senates, and White Houses of every conceivable partisan combination. During that same time period, you've seen not only the accumulation of power, but also the accumulation of wealth. It is, I believe, no coincidence that currently, as we sit here today, 6 of our nation's 10 wealthiest counties are now suburbs of Washington, D.C. This notwithstanding the fact that it's not a banking hub, it's not an area that manufactures anything, it's not a technological innovation hub, it's not the home of any vast store of natural resources. No, the money is here because the power is here, concentrated in the hands of just a few elites. So in that respect, it should come as no surprise that there are people who spend an extraordinary amount of money trying to make sure that they can get access to that power that power that controls as much of the economy as it does, as much of the lives and livelihoods as it does. There are people willing, whether they are rich or poor or somewhere in between, to invest a whole lot of money in trying to influence government. So I wonder, why is it that we're so slow to ask the question, why do we allow this much power to be accumulated in government? Why do we allow this much of our government to be based in Washington rather than with the people? And why within Washington do we allow so much of that power to be accumulated in the hands of the few within the administrative regulatory state? This has a whole lot to do with why we've seen the rise of super PACs, with why we've seen the rise of billionaires, millionaires, poor people, rich people getting behind political causes of one sort or another. This, of course, giving disproportionate advantage to those who have a lot of money to influence government. There are people on the left and on the right devoting a whole lot of time and a whole lot of resources, a whole lot of influential capital to doing just that. That should be concerning. That is, I believe, a symptom of the true underlying malady, which that we've allowed too much power to accumulate right here. So as long as we're asking the question of aren't these super PACs dangerous, which I think few Americans would quibble with that. I think few Americans would say, yes, I love super PACs. I think they're the best thing ever. I don't think many Americans would say, yes, we ought to have that much power that can be wielded by the rich and powerful or by political interests. I don't think many Americans would disagree with that. But we ought to ask ourselves, why is it that they have such an incentive to do this? Why do they want to spend so much of their money doing this? What is it they have to gain? And have we made it too easy for too many of them to gain too much simply by trying to influence government? But in that discussion, I hope we will never lose sight of the fact that we do have a treasure in the federal judiciary, a treasure that should never be diminished as an organ of any political party or any interest. The rule of law is a cultural norm that is not easy to establish, and once established, needs to be maintained. I hope we can do that. Judge Gorsuch, I'd like to talk to you about some of the issues that have been raised with you. You've had some members of this committee asking you to opine on specific legal issues, on specific cases or types of cases. And some have even expressed frustration about the fact that you haven't said more in response to their questions. I'd like to ask you a few questions about that and about the issues that could come along with that. And I find it significant and worth mentioning here that in a recent op-ed published in the Washington Post, two of your former colleagues, Judge Taha and Judge Henry, both of whom I believe are here. I think I saw them earlier today as a lawyer who's argued before each of them many times, sometimes winning, sometimes losing. I was glad to see them here.
Yes.
But they issued this opinion, this op-ed about the issue of judicial independence. I assume you saw the op-ed, or maybe you were aware of it.
I'm aware of it.
But they wrote, among other things, as follows. I want to quote this. They said, quote, "Detailed discussions during the confirmation process on issues that might come before a judge are not proper. In fact, they would in all likelihood require recusals from the cases discussed. Litmus tests are not acceptable," close quote. So Judges Taha and Henry, both of whom have served as chief judges on the 10th Circuit, make an important point. If you were to rule, if you were to make a commitment today as to how you might rule on a certain issue, on a particular type of case, and if that issue were subsequently to come before the Supreme Court of the United States, and if by then you have been confirmed as an Associate Justice of the Supreme Court of the United States. Isn't it possible, and in fact, isn't it likely, that a litigant could file a motion for your recusal in that case?
Yes, Senator, and I really want to thank Judge Taha and Judge Henry, both of whom are retired from the bench, for having gone out of their way to write that article together and to come to Washington. And I think you're going to hear from them tomorrow. One happens to be a Republican-appointed judge. The other happens to be a Democrat-appointed judge. And again, I don't buy into those labels. They're judges. And they both led the 10th Circuit. They're people I admire greatly and esteem personally. And so you're absolutely right. I would face the possibility of a recusal motion, and I'd have to face the litigant in front of me who would say quite reasonably, look me in the eyes and say, how can you be fair in my case when you've already opined on its contents in front of the United States Senate? And I, to be honest with you, Senator, I don't know how I look them in the eye. And whether that means I'm on the Supreme Court of the United States and fortunate enough to be confirmed, or I go home to Colorado and those cases come before me, I'm still faced with the same predicament. Yes.
And if such a motion were to come forward, it's not exactly the kind of circumstance in which you'd say, well, that would be frivolous. It's not necessarily an act of paranoid fantasy to say such a motion for recusal could be filed.
No, Senator, which is why we have a judicial canon that prohibits me from opining on cases that might be pending or impending. And, Senator, there's a second reason that I think is vitally important, too. It goes beyond the parties. It goes to the integrity of the judiciary itself. If persons coming to this table, this rather lonely table in this rather big room, have to make promises or hints or previews or nudges and gestures about how they're going to rule in cases, then I don't know where we are as an independent judiciary. It's like a campaign promise for office, it seems to me. And you know what? It hasn't happened so far. The precedent in this area is strong. And I admire it. I've looked back. I'm no expert. I haven't read every jot and note. But Justice Ginsburg, Justice O'Connor, Justice Souter, Justice Scalia, all of them declined to offer hints and previews. And, Senator, I'm not going to be the first judge to come to this table and break that tradition and compromise the integrity of the independent judiciary.
So that tradition, while strong, like any chain, could be damaged, could be undone by its weakest link.
That's right.
You don't want to be that link.
I'm not going to be that link, whatever happens to me.
And if, in fact, answering questions that you shouldn't answer could trigger a motion for your recusal, and if a motion for recusal that might be filed as a result of your answering such a question would not necessarily be frivolous, might end up having to be granted, that could create additional opportunities for mischief, and that people could deliberately plant questions, directly posit questions, demanding that you answer them as a condition of your moving forward in this committee, questions themselves that could result in your non-participation in a particular case, thus opening this process up for manipulating that process and undermining the integrity of them both. Would that be an accurate characterization? Would I be crazy to suggest that?
Senator, I should hope that's never any person's motive.
And I'm not suggesting that it is any person's motive in this case. What I am saying is that if we weaken that link, that could easily become the motive, given what we know would likely be the outcomes.
That would be, I think, a poor day for the United States courts.
One of my colleagues criticized your opinion in Longhorn Services Company versus Perez. So I went back and looked at that case. Here's what happened in essence. Longhorn, the company involved in the case, prepares wells for fracking by lowering a metal platform over the well, inserting piping through the platform, and pumping contaminants into the well. OSHA came to inspect the well and cited the company for a couple of reasons. The company ended up challenging OSHA, and the company prevailed on one of its claims, and it lost on one of the other claims. I think it's significant that when the accusation is being made, that this somehow reflects a determination on your part or a bias on your part to favor the big guy and rule against the little guy. That's misguided. It's wrong in this case for two independent reasons. First and foremost, there is no bigger big guy than the federal government. There is no stronger Goliath than this government. It's not to suggest that its intentions are malicious. It's only to suggest that this is a formidable foe. I don't think it would ever be fair to say that someone litigating against the federal government is anything other than the little guy, especially whereas here it's not as if the business were a giant corporation known by all people. Secondly, there were two claims at issue in this case. Only one of them was one upon which the business entity prevailed. I see my time has expired, and as I would always do before your court, I will stop talking once my time has expired. Thank you, Judge.
Thank you, Senator.
Thank you, Senator Lee. Now, Senator Klobuchar.
Thank you very much, Mr. Chairman. Good day again, Judge. I really had promised I was going to start with antitrust, but the real world has intervened again, as it does very often. And so I'm going to lead off asking about the case that was decided today by the Supreme Court. And let me start by saying I care a lot about this issue of kids with disabilities. When my daughter was born, she couldn't swallow. And for a year and a half, she was fed by a tube. She ended up not having a long-term disability, but it made me really understand, because I got to know a lot of these parents through this time, what they go through every single day. And while I can wear my politics on my sleeve about where I am on this issue, I know that you are a judge and must make decisions. And our job here, and I've tried to stay away from making these political statements. I've tried to stay away from asking how you're going to decide a certain case in my questions yesterday. But we have to figure out what your philosophy is. And so that's why we keep going into such excruciating detail, as you know, about these decisions that you've made in the past. So what happened this morning was that the Supreme Court unanimously rejected, in an opinion by Justice Roberts, the standard that you used to evaluate how much help kids with disabilities get in school. It wasn't your case, but it was a standard that was like the standard that you used, and 9 justices disagreed with you. Justice Roberts' opinion says, when all is said and done, a student offered an educational program providing, quote, merely more than de minimis, end quote, progress from year to year can hardly be said to have been offered an education at all. Now, ironically, he actually called out the language that you used in that 10th Circuit case. And he said, whatever else can be said about it, this standard is markedly more demanding than the merely more than de minimis test applied by the 10th Circuit. So I want to start where Senator Durbin left off in his initial question. And you said that you decided Thompson R2J School District v. Luke P. the way you did because you were affirming precedent in Urban v. Jefferson County School District, which is, of course, a case in your circuit, and you said so you were bound by it. So over our brief lunch break, I looked at it, and I'm just not sure that's true, and maybe we just have a different interpretation. I know this is going to sound nerdy to people that aren't lawyers, but this is our job today. And a holding, of course, is precedent. It's part of a court's opinion that's later binding on courts, but a holding is different than dicta. And when I look at this case that you wrote the decision yourself, and yes, some other judges joined you, but you wrote it. And I look back at the case you relied on, and it actually mentions this de minimis standard, but it's just in a paragraph along with some other standards. It's a Third Circuit case that uses this de minimis standard, and the actual 10th Circuit case uses a broader standard. And so in the end, even this section of the case isn't used, that case isn't used to decide it. It says we don't reach the issue. So for me, this case that you said was binding on you, it's just dicta in the case. It's not a holding. And so to me, you actually were the first in this case that you wrote to come up with this standard, and then you actually made it, which I'll get to in a second, you added the word merely. But why don't we just start with, don't you see this as more dicta than as a holding?
Senator, I'd have to go back and look at it carefully, but no, I wouldn't agree with that. My recollection is that the 10th Circuit precedent was very clear that some meant more than de minimis. Some meaningful educational benefit in Rowley was the Supreme Court precedent, and that our court had interpreted that to mean more than de minimis, and that a number of circuits had come to the same conclusion. The Supreme Court didn't take this case just for fun. It took it because there was a circuit split on this issue. And the 10th Circuit was with the 3rd Circuit, and I believe there are probably some others. I'd have to go back and look at it. You have it before.
No, there were some other circuits.
Yeah,
yes.
so that's what happened. That's what the Supreme Court does, is when circuit judges disagree in the rare cases.
Yeah, and I do understand that, but what I'm saying is...
And to suggest that we were in any way out of the mainstream, or that I was doing anything unusual there, would be mistaken, because it's the standard used by many circuits up until, I guess, today.
Okay, but it was a 9-0 decision against the standard, so to me that does seem out of the mainstream, and also...
Which is wonderfully reaffirming to me, Senator, that again, even in cases where circuit judges disagree, and here's one where there was a circuit split, and as you point out, it sounds like a lot of circuits on both sides of the issue, and a technical issue, and maybe a little nerdy, as you say. But that's what we judges do. We're trying to follow the precedent as best we can. Sometimes we get disagreements. And then the Supreme Court, exercising collegiality, comes together and resolves it.
Okay.
That's how our system is exactly supposed to work.
I understand. But let's go back to this again. So here's my position is that this was not necessarily binding, this case that you cited. But then beyond that, this Third Circuit case that wasn't binding, that you cited, that says it must be more than de minimis, you went a step forward, and this is what Senator Durbin was getting at. You added the word merely, so you said it's merely more than de minimis. So I was trying to figure this out at lunch, and I figured out that if you had a gas tank and it said it has to be more than empty, that could mean it be any way up to full. It's a broad range of the kind of how full your gas tank would have to be. But you added this word merely. So you said the standard is that it has to be merely more than de minimis, or in a gas tank, merely more than empty. That implies something entirely different. That creates a ceiling, to me, more than a floor in its language. It's a ceiling, because it says, well, the standard is it has to be merely more than de minimis, as opposed to more than de minimis. And so that's something else where I think you actually took something that wasn't necessarily a precedent, you added the word merely to make it even more narrow, and so it's not a surprise to me then that the Supreme Court 9-0 rejected that language. Any response on that?
I disagree.
Okay. And then the next question I have is that in some of these other cases we talked about yesterday, you did a separate concurrence. So even if you're right and I'm wrong, and you were somehow bound by a Third Circuit case when you wrote that opinion, maybe you could have written a concurring opinion like you did in Chevron, you wrote in the Gutierrez case, you wrote in a concurring opinion to your own opinion expressing a view that was different than the one that was binding on you. So you could do it in this case as well. So why pick Gutierrez case or Riddle v. Hickenlooper to do a concurring opinion and not a case like this one that is really about the kind of services that a child with autism are going to get?
Senator, I've written cases for families in IDEA cases, these Individual with Disability and Educational Act. I've written decisions against the families in these cases. And in each case, Senator, it's been based on my assessment of the facts and the law. And the opinions I've issued or not issued have been based on my assessment of the facts and the law. Not any personal animus, not any wrong motive, Senator. I can assure you of that. And any suggestion otherwise would be mistaken. Mm-hmm. And, Senator, all of these opinions in the 10th Circuit that we're talking about have been unanimous. Yeah. Every one of them, including this one. And, Senator, to suggest that it's somehow out of the mainstream, I'd respectfully ask you to look at who joined the opinion. And you'll find one of my colleagues, who happened to be appointed by a Democrat, joined that opinion. And you'll see other opinions where I've joined Republicans and Democrat-appointed judges ruling for the family. Mm-hmm. And so, Senator, all I can say is I was trying faithfully, to the best of my ability, to follow Supreme Court precedent in Rowley, the 10th Circuit opinion as I understood it in Urban, and a number of other circuits had interpreted Rowley in the same way. And my colleagues subsequently after me interpreted it in the same way. This decision that was under review was by another separate panel of the court, the one that just went to the Supreme Court. My colleagues in a separate panel made up, I believe, again, of Republican and Democratic.
Okay, but the difference for me and all of us up here today is they are not up for the job of the highest court of the land. And in this case, you wrote the opinion and you told us that that earlier opinion was binding precedent. And I'm not certain that it was because the words were from a different circuit. And so, you know, I guess we will disagree on this, but I am not questioning, this is something where I'm actually trying to get at your judicial philosophy. I have no other way to do it except to look at these opinions. And I want to move on here because I brought up the Chevron case before, and then I also found out that in 2015, you sought to revive the non-delegation doctrine, which restricts the amount of discretion Congress may choose to delegate to federal agencies. You did this in a dissent, but it was something that hasn't been used since the 1930s. It was used twice in the 1930s. And again, it seems to me like in certain things, and what it does basically is says that Congress can't delegate its legislative powers to agencies, and I think there's a reason other courts haven't used it. But it feels to me like you pick certain types of cases where you are kind of reaching really broad and going back to doctrines from the 30s, and then you don't do that for other kinds of cases that certain people in America would care about. So I'm trying to figure out why you pick certain cases to write concurring opinions on and to be more broad, and then other cases where you really stick to the text. And that's what I'd like you to answer.
I always try to stick to the text, Senator, with respect. And in this case, again, it was following a 10th Circuit precedent that was 10 years old at the time. And sometimes the 10th Circuit will often adopt standards from other circuits that it finds persuasive. And it may have, in that case, you say, adopted it from the 3rd Circuit. I don't have it in front of me, but I believe you. And often my colleagues will adopt, and I will too, standards by other circuits. Rather than reinvent the wheel, we will say we agree with another circuit. And that's how law is decided in cases. It's part of precedent. It's the respect due a persuasive opinion by a colleague, a thoughtful colleague. And every one of these judges in every one of these cases does their level best. And circuit splits arrive only because judges are doing their level best to interpret the law. Mm-hmm. And in this case, there were, as you point out, several circuits, it sounds like, on both sides of this question, an honest interpretation effort of the statute before us in light of Supreme Court precedent.
And so do you want to comment at all on the non-delegation doctrine?
I'd be happy to. The case that you're referring to involved the Sex Offender Registry and Notification Act. And Senator, why I chose to write there was the same reason Justice Ginsburg and Justice Scalia wrote in the area. Because in that case, the law, as enacted, sent to the Attorney General essentially the discretion to write a law. And the legislative powers invested in this body, not in the Attorney General. A particularly odd place to delegate legislative authority, not just to some agency with expertise, like with biologists or chemists, but to the chief law enforcement officer. And to send to the chief law enforcement officer the opportunity to write a criminal law. Well, Justice Ginsburg and Justice Scalia, again, people think they don't agree Well, they often do. And here's an example.
But is there a way to get there without pulling out this doctrine that hadn't been used since the 1930s?
Well, Senator, it's a point they made in an opinion. And I had a subsequent case raising that question, and I thought it was important to address.
Okay, I wanted to just go back on one point. We had a long discussion yesterday about originalism, and I think you and I agreed that he can mean she in the text of Article 2 of our Constitution, meaning we can have a woman president. I was just using that as an example, that not everything in the text is exactly as it should be or will be construed. We agreed that Congress's authorization of the Navy and Army also provided for the authorization of the Air Force. But then we got to that United States v. Virginia, and you say you can also get to the outcome of Justice Ginsburg's majority opinion in that case, where the Virginia Military Institute's male-only admission policy was found to violate the Equal Protection Clause of the 14th Amendment, and sort of you get there through radical original meaning. And what I thought was interesting there, compared to the other two examples, was that Justice Ginsburg's majority opinion had nothing to do with original public meaning, and the cases she relied on to get to that point also had nothing to do with original public meaning. And so when you have to decide cases that deal with social changes that the general public could never have anticipated back when the Constitution was written, aren't you just relying on the intervening decisions of non-originalist judges to get there? So when you said, well, yes, that's fine, it's precedent, it's Justice Ginsburg's opinion, that's because Justice Ginsburg was a non-originalist in how she interpreted, and then you in turn rely on her opinion to get to the point that it's okay and a normal outcome. So I'm trying to get at, because
I'm not sure I track the question.
Sure. The question is that it's selective originalism. Sometimes you use originalism at its core, and then sometimes to get to an outcome that's more normal, you don't use originalism. You couldn't in that case of Virginia Military Institute, but you rely on non-originalist judges to get to the outcome.
If I think I understand the question, I think the answer is precedent. A judge always starts where he or she finds themselves. We don't live in a vacuum. I'm not writing on a blank slate as a judge. I am not, a philosopher king. I'm a judge of cases. That's my job. And so you take the precedent at hand. And Senator, that's a very important thing to me.
Isn't another way to look at it, I went to University of Chicago Law School, and Judge Posner taught there for years, and I know you disagree with his account. He's a Republican-appointed judge, and he said that it was naive to think that judges believe only in the legal technicalities of their argument, especially when you get, he didn't say this, I'm adding this part, especially when you get to the highest court of the land. The truth is, he says, that they consult their own moral convictions to produce the best results for society. And you don't agree with that, but I'm just trying to get, when you get to this highest court of the land, where, by the way, I said it was 9-0 decision, it was an 8-0 decision, because there's only 8 justices there, my earlier question of you. When you get to that highest court of the land, it seems to me that Posner is being honest, that people do consult. They try to apply the law, but when you're at that last court in the land deciding things, oftentimes they are grounding their decisions in where they are morally about how what these outcomes are going to be. Is there any merit to that at all?
Senator, I can just say that's not been my experience. I've been doing this a long time, and I respect Judge Posner greatly, as I know you do, and I respect you greatly and your view. I can just speak to my view. Maybe I'm just more optimistic. You can call me naive if you want. But my experience watching Justice White, Justice Kennedy, all of the justices of the Supreme Court who have been mentioned here today, every one of them, I believe is doing his or her level best to apply the law based on the facts and circumstances. There's realm for some disagreement. There's not a single right answer to every case. I will concede you that. But that doesn't mean, just because there isn't a single foreordained answer from God, in every legal dispute, that judges aren't trying to look at the legal materials and only the legal materials and try to make sense of the legal materials and that alone, and leaving the rest of the stuff aside. That's been my experience of good judges. They leave their moral convictions, their views about social utility, whatever it is, whatever they ate for breakfast, over there. They take the briefs, they take the law, they take the facts, they take the Constitution, they take the precedents, they take the original understanding, and they try to make sense of it, as a judge does. And that's just not how a politician thinks, respectfully. It's not how a citizen thinks about ordering my daily affairs.
Okay.
But
So
as
you
a judge, I'm sorry.
Yeah, and you and I actually share that view. It's just that's not these decisions that Senator Whitehouse has outlined, other things that have been happening. It doesn't feel that way. And I have respected Republican-appointed judges and Democrat-appointed judges. We've had judges that actually won't make decisions in my county days on the Mondays after a Viking game because they thought it would affect them too much.
Exactly.
With the outcome. All right. But
That's what I'm talking about.
But the point is, that's why I brought it up. Yeah. But the point is that this just doesn't seem to be happening lately with these decisions like Citizens United in the court that you want to serve on. And so I'm a fixer. I like to fix things. And one of the ways I can fix that is by making sure that we put judges on there that are going to view themselves as true fair jurists and not legislators making change. And the second thing is by some of these things I brought up earlier, and I'll just end with that. Cameras in the courtroom. Thank you, Senator Grassley, for your leadership. But the second is the ethics rules, and I just wanted to make 30 seconds here. Yesterday when you and I talked about it, you said you didn't know how different they are between the regular federal judiciary and the Supreme Court. Actually, the Code of Conduct for United States judges adopted in 1973 applies to every federal judge other than the justices of the Supreme Court. And that includes reporting, of course, trips and gifts and things of value. And so I do ask you, as you look at ways, if you are confirmed, if you looked at ways to bring back, I think, some trust. We're struggling with that, obviously, right now in the Congress. But one of these ways is to be as transparent as possible. And that means, to me, cameras in the courtroom, and it also means having the ethics rules applied to the Supreme Court. And I have a lot of respect and enjoy the justices there now, but I think that would be a very positive move. Thank you.
Senator Cruz.
Thank you, Mr. Chairman, and congratulations, Judge Gorsuch, on making it through day 2 of the gauntlet and continuing to do so with flying colors. I want to go back to a topic that Senator Lee addressed a few minutes ago, which is we've heard over the past several days a number of my Democratic colleagues in Congress bemoan and condemn, quote, vicious and reckless and personal attacks against judges. What they have called a, quote, unprecedented attack against the credibility and independence of the judiciary. And so if I understand their argument correctly, it is completely inappropriate. It is an absolute abuse of power to criticize, to malign, to attack judges. Now, if that's their argument, Mr. Gorsuch, I've got a question for you. What position do you currently hold?
I'm a judge on the 10th Circuit Court of Appeals.
And if the Senate were not to confirm you to the Supreme Court, what position would you continue to hold then?
One I happily enjoy now.
So if you are and will continue to be a federal judge on the Court of Appeals, it's interesting to assess how my Democratic colleagues have fared under their own test, that it is inappropriate, that it is offensive to somehow malign a federal judge. Former Speaker Nancy Pelosi said on national television, Judge Gorsuch is, quote, hostile to women's rights and holds radical views far outside the mainstream of American legal thought. She continued, quote, what saddens me the most as a mom and a grandmother is his hostility towards children in school, children with autism, She additionally went on to say, quote, "If you breathe air, drink water, eat food, take medicine, or in any other way interact with the courts, if you care about that for your children, he's not your guy." It's interesting, given the Democrats are complaining about people criticizing federal judges. Senator Whitehouse on Monday said, quote, "Tellingly, big special interests and their front groups are spending millions of dollars in a dark money campaign to push your confirmation. They obviously think you will be worth their money." That also somehow falls short of the Democrats' complaints about criticism directed at the judiciary. Indeed, Senator Hirono on Monday said, quote, "You consistently choose corporations and powerful interests over people. Ideology over common sense, and indeed the purpose of the law." Senator Durbin, "In case after case, you either dismissed or rejected efforts by workers and families to recognize their rights and defend their freedoms." Senator Franken, "But if the past is prologue, then I fear that confirming you would guarantee more of the same from the Roberts courts. Decisions that continue to favor powerful corporate interest over the rights of average Americans." Tom Perez, the DNC chairman, "Gorsuch on the Supreme Court is intolerable. Judge Gorsuch would discriminate against a majority of Americans from the bench." The chairman of the Democratic Party charging that a judge would discriminate. These are serious attacks. Many of them impugn your integrity directly. And yet, this is a confirmation hearing. The founders understood a confirmation hearing would be in the political arena. My colleagues, the Democrats, have a right to engage in whatever attacks they choose. But it's a little rich for them to be maligning a sitting federal judge and at the same time giving speeches about how unacceptable it is for anyone to criticize a federal judge. You can't have both at the same time. Now, I'm not going to ask you to respond to any of these attacks. I actually think these attacks speak for themselves. But I will ask you this. As a judge today, and as I believe a justice in short order, will you pledge to be faithful to the law and the Constitution and neither favor nor disfavor any litigant based on who they are?
I guarantee you no more, and I promise you no less.
That is precisely what we should expect of judges. Let's turn to a different topic. In the last couple of days, we've heard a lot of discussion about originalism, textualism, and the Constitution. And some of my colleagues have suggested that understanding the Constitution as having a fixed and original meaning somehow prevents the Constitution from changing to meet changed circumstances. Judge Gorsuch, did the Founding Fathers, in all of their wisdom and foresight, did they anticipate that the Constitution might need updating, and did they provide any mechanism to update the Constitution should new challenges arrive?
Yes, Senator Cruz, they did.
And what was the mechanism that the Founding Fathers created?
There's a process for amending the Constitution.
And has that process been employed?
It has, Senator, from time to time.
And it has worked quite well, I would note. Now, I understand that there has been some discussion today about the Supreme Court's decision in Andrew F. versus Douglas County School District. This morning, the Supreme Court issued the opinion that abrogates Judge Gorsuch's opinion in the Luke P. case. Andrew F. originated in the 10th Circuit, but you did not sit on the original panel.
No, Senator, I did not.
And as I understand it, 10th Circuit precedent from 1996 and drawn from the Supreme Court's own opinion in Board of Education versus Rowley in 1982 held that a school district is compliant with IDEA so long as the student is, quote, making more than de minimis progress in school. My Democratic colleagues have repeatedly demanded over the last 3 days that Judge Gorsuch follow precedent. And indeed, I will commend them for highlighting this case as yet another example of Judge Gorsuch doing exactly that, following precedent in the 10th Circuit, that itself was following precedent from the United States Supreme Court. Judge Gorsuch, as a judge of the 10th Circuit, were you bound to follow 10th Circuit precedent?
Yes, Senator.
And if the Supreme Court changes the precedent, are you then bound to follow the new precedent?
Yes, Senator. That's how it works.
That is precisely how it works. And in this instance, the fact that you followed precedent faithfully should give comfort to senators on both sides of the aisle, that you will continue to do so as a Supreme Court justice. I'd now like to introduce several items into the record. I want to start with a letter from Supreme Court practitioners. I'd like to enter into the record as a letter from a group of attorneys who combined have argued over 500 cases before the United States Supreme Court. They include lawyers who clerked for Ruth Bader Ginsburg and Stephen Breyer, and the signatories unanimously support Judge Gorsuch's nomination. These accomplished attorneys called Judge Gorsuch fair-minded, dedicated, smart, and unfailingly polite. And they tell us that they would be pleased to appear before him. They conclude by saying he has, quote, an unusual combination of character, dedication, and intellect that would make him an asset to our nation's highest court. I'd like to enter this letter into the record.
Without objection, so ordered.
I'd like to also enter into the record an article from Evan Young, a former law clerk to Justice Scalia. Mr. Young writes that Justice Scalia, quote, did not want to rule the American people by imposing even his most cherished personal beliefs on us. He wanted the American people to rule themselves, something that he could facilitate by being a relentlessly principled judge, telling us what the law required and then letting the country make his own choices. Based on his record, Judge Gorsuch exhibits that same judicial humility. He understands that he should never confuse the law's commands for his own ideas of what the law should command. I'd like to enter this article into the record as well.
Without objection, so ordered.
I'd also like to enter into the record an essay from Michael McConnell, a former colleague of Judge Gorsuch on the 10th Circuit, and a very well-respected legal thinker across the country and indeed across the globe, who writes that the President could not have made a finer appointment to fill Justice Scalia's seat. What I found especially enlightening was the way Michael McConnell not only addresses the intellectual seriousness of Judge Gorsuch's jurisprudence, but also testifies personally to the strength of his character. Judge McConnell writes that Judge Gorsuch was a man defined by his gracious personality, someone who always treats everyone with respect. He actively engages with lawyers, listens carefully to their position, and reflects fair-mindedly on what was said. Judge McConnell concludes by noting that ultimately Judge Gorsuch is, quote, the kind of justice Americans of all political stripes should hope for. I'd like to enter this essay into the record as well.
Without objection, so ordered.
In addition, I'd like to enter into the record an article from the Wall Street Journal that describes Judge Gorsuch's strong defense of religious freedom for everyone. The article quotes Judge Gorsuch's legal reasoning in a Religious Freedom Restoration Act case, where he explained that, quote, the Act doesn't just apply to protect popular religious beliefs. It does perhaps its more important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge of religious tolerance. I'd like to enter this article into the record as well. And one final entry, I'd like to enter into the record a letter from Scott Barker, a longtime Colorado Democrat and a practicing attorney in Denver. He urges the confirmation of Judge Gorsuch, saying that he has, quote, performed admirably as a 10th Circuit appellate judge, and that, quote, you would have to look long and hard for someone in the Colorado bar who would say a disparaging word about Judge Gorsuch. I'd like to enter this letter into the record as well. And with that, Mr. Chairman, I yield my time.
Thank you. I'll take the 7 extra minutes of Senator Cruz's time. Judge, hi. During our courtesy visit, I asked you if you'd read the New York Times investigative series on the pervasive use of forced arbitration. You hadn't, but you said you would. Were you able to do so?
I was. I managed to fit it in, Senator.
Thank you. Thank you so much.
No.
I said, you don't have to read this. And you said, no, I will. I promise. And you did. So thank you. I don't think that most Americans realize that when they sign up for a credit card or cable service or sign an employment agreement or fill out their parents' nursing home resident agreement, that they're also signing away their constitutional right to go to court. The New York Times series, while shocking, illustrated something that I have been saying for quite a long time. Forced arbitration clauses, which are buried in the fine print of contracts that we sign every day, restrict Americans' access to justice by stripping consumers and workers of their legal rights and insulating corporations from accountability. Businesses across the nation use these clauses to force individuals into a privatized justice system where the corporation can write the rules, everything can be done in secret without public rulings, discovery can be limited, making it hard for consumers to get the evidence they need to prove their case, and there's no meaningful judicial review, so there's not much a consumer or employee can do if the arbitrator gets it wrong. It's simply unfair. Now, there seems to be no question about how arbitration clauses came to permeate nearly every aspect of our lives. In a series of decisions, including Rent-A-Center, Concepcion, and Italian Colors, the Roberts Court effectively reshaped the Federal Arbitration Act into a permission slip for corporations to opt out of the civil justice system. And in the years since, we've seen business after business use arbitration clauses to avoid accountability for their wrongdoing under even the most egregious of circumstances. A few years ago, my staff heard the story of a 71-year-old man at a nursing home who died from, quote, profound dehydration, and whose family was forced into arbitration to resolve their wrongful death claim. Last year, we learned that Wells Fargo customers who had had fraudulent accounts opened in their name and without their consent were forced into arbitration because the bank successfully argued that the clause in their real accounts also applied to their fake accounts. Very recently, Fox News tried to force its former anchor, Gretchen Carlson, into arbitration when she sued her boss, Roger Ailes, for sexual harassment. Fox News also tried to use the arbitration clause in her employment contract to prevent her and other victims of his abuse from speaking to anyone about what had happened to them. Companies have also learned to pair forced arbitration agreements with class action bans to shutter the courtroom doors to groups of individuals with small claims. And once blocked from going to court as a class, most people drop their claims because it doesn't make financial sense to go it alone. Now, this way of doing business is profoundly unfair and unjust. It is anathema to our system of civil justice, and it doesn't even scratch the surface of the many stories that the New York Times series revealed. Judge Gorsuch, what was your reaction to the series? Were you shocked? Because I've worked on this issue for 8 years now, and even I was shocked.
Senator, it made me think about a little bit of history. It used to be back at common law that arbitration was disfavored because it was thought that everyone should go to trial. Trials were the norm, Seventh Amendment and all that. And then in about, I think in 1925, Congress passed a law called the Federal Arbitration Act.
24.
24, okay, all right.
Very, very close.
All right.
As close as you can get without being right.
I try.
Yeah, it's very, very good, very good.
And it made me think of that. It made me think, well, gosh, it doesn't have to be this way. The Federal Arbitration Act, what it did was to favor arbitration. Congress expressed a preference that people should arbitrate their disputes. It made a judgment, policy judgment, in favor of arbitration because it's quicker, cheaper, easier for people.
But that was really conceived in 1924 as two equal parties, business to business.
Yeah.
And what I'm gonna continue on here, because I mean, unless you want to.
Well, I wasn't quite finished, but if you, it's your time.
Finish.
I don't.
It is my time, but if you can do it short, why don't you finish your
I'll do
thought?
the best I can.
Okay, thanks.
If Congress thinks that the courts are not applying the Federal Arbitration Act as it wishes, or if it wishes to revise or eliminate the Federal Arbitration Act, I mean, 1924 is a long time ago. And
well, my feeling is that the court, through these 5-4 decisions, the Roberts Court, has changed what the intention of the law was back in 1924. But I'm going to continue. In our courtesy visit, you emphasized the threshold question that you say the Federal Arbitration Act requires. In the opinion you authored in Howard versus Federal Gas, you discussed how, when dealing with arbitration clauses, courts must first determine whether an agreement to arbitrate between two parties actually exists, and you go on to detail the analysis of the contract formation principles that must happen in order to make that determination. I think I understand what's required in that threshold question, but in order to fully grasp how you will approach the issue of forced arbitration going forward, I want to move on to the next step in the analysis. So assuming the parties did in fact form a contract, I want to know whether there are any circumstances under which you believe that the mandatory arbitration clause should not be enforced. In other words, let's talk about the practical outcomes that arise when courts enforce these clauses, and whether, in your view, any of them make clauses so unfair that you would deem them unenforceable. I'll give you an example of how forced arbitration affected a Minnesota soldier who was deployed at Camp Anaconda in Iraq. Now, I know Camp Anaconda. I visited 4 times on USO tours. I'd go there, I'd tell a few jokes, and then leave very quickly. See, Camp Anaconda has a nickname. The soldiers there called it Mortaritaville because it was hit so often by enemy fire. And in fact, the first soldier I ever met in Walter Reed had both legs, lost both of his legs to a mortar at Camp Anaconda. Well, one soldier who was deployed in Anaconda, Minnesota soldier, learned while he was there that his house had been foreclosed upon and sold in clear violation of a law we wrote, Congress wrote, the Service Members Civil Relief Act, which protects service members from civil actions while on active duty. The mortgage lender had falsified paperwork stating under oath that the soldier was not in military service. So the house went into foreclosure, and was sold at an auction for a third of its assessed value. Can you guess who bought it? You can't, right?
I can. You've shared this with me before, so I actually know who bought it.
Oh, okay. Well, then
That's okay.
not fair. The bank.
The bank, right.
The bank.
Right.
It turns out there were over 80 other foreclosures that had taken place against service members by the same lender. So the soldier tried to file a class action suit on behalf of his fellow service members. Unfortunately, a mandatory arbitration clause, which the soldier didn't even realize was buried in his mortgage documents, also included a ban on class action suits. So his case was not only forced out of court and into arbitration, but he had to go alone. Now, fortunately, the Minnesota soldier had a lawyer willing to take on his individual claim, even though it's often that's not cost effective for the lawyer. They eventually settled on terms that are confidential. As a result, we have no real way of knowing how many other service members' rights were violated or whether this particular service member was ultimately made whole. And of course, he was prevented from even telling the other 80 service members who had been harmed how it all went down. Judge Gorsuch, this is a case where we know the law was violated. We know that a bank unlawfully took this soldier's home while he was away serving our country. And to add insult to injury, the man also lost his constitutional right to have his claim heard in a public court of law. So tell me, was it fair to limit this soldier's claim to secret arbitration and to prevent all the soldiers who had also lost their homes from being included in this case?
Senator, I'm a big believer in jury trials and in the Seventh Amendment. And in the Rules Committee over the last 6 years, I've worked with my colleagues to try and make litigation cheaper, faster, and more accessible so that people can vindicate their jury trial rights. Got a proposal with a wonderful judge from the Ninth Circuit, currently pending before the Rules Committee, asking if we can actually reverse the presumption. Because right now, when you file a complaint in federal court, if you don't specify that you want your jury trial right, it goes away. And you're presumed to want a bench trial. I don't understand that presumption. I think it should be the other way around.
I'm talking about in these agreements, on this particular agreement. This is settled. This case is settled. This is not a live controversy. The thrust of my question is, when do the principles of equity and fairness apply? So once there is a determination that there is indeed a contract, what does it take for the courts to decide that the outcome is so unjust that it cannot be enforced?
Well, under the Federal Arbitration Act, which is an act of this Congress, an act of lawmaking by this Congress, the first step and the key step is, did the parties agree to arbitrate? And normal state contract formation principles apply there.
I know. We talked about that. That's the initial test.
I think it's very important, though, Senator. If you're asking me the question, I have to give you the answer. And the answer is, under normal state contract formation principles, there are a number of defenses that can be raised. Unconscionability might be an argument, if I were a lawyer in this case, that I'd want to raise in the case you're presenting. That would be an argument I would raise.
Don't you think this was unconscionable?
That would be an argument, if I were a lawyer, I would want to raise. I don't know how I'd come out. I'd have to have the full judicial process in order to adjudicate it, but that would be an argument. If I were the lawyer, that's one I would make. Right? I'd also, if I were a lawyer and worried about these things, come to this body and ask you to revisit a nearly 100-year-old law and perhaps rethink the balance between arbitration and jury trials.
Well, I've done that with my Fairness and Arbitration Act, which I keep introducing. Let's turn to the secretive nature of forced arbitration. Last year, the public was shocked to learn that over the course of 5 years, Wells Fargo employees have been incentivized to open millions of sham accounts in the names of Wells Fargo customers and then charge the customers for those accounts, of course, without their permission. Many of them lost their credit rating, just plummeted. this was a bad outcome for these people. One reason this fraudulent practice was allowed to continue for so long was because Wells Fargo's customer account agreement included and continues to include a forced arbitration clause. When customers discovered and attempted to sue Wells Fargo for the sham accounts, the company argued successfully that any dispute arising from the sham account was covered by the arbitration clause in the real account. So those customers were forced into secret arbitration. One such complaint was filed in September of 2013. If that suit had been able to proceed in court, other Wells Fargo customers could have been alerted to the wrongdoing and may have been able to save themselves from being charged for the sham accounts. And the life-changing damage it did to their credit scores, to their bank accounts, to the ability to buy a house. Judge Gorsuch, would you agree that one benefit of our civil justice system is ensuring that other victims are made aware of widespread wrongdoing and that such awareness allows them to mitigate the harm for themselves?
I've spoken about that very issue, Senator.
Good. Now, it doesn't just hurt customers. It hurts employees. 2 weeks ago, I, along with a few of my colleagues here, introduced a number of bills aimed at combating unfair forced arbitration clauses. In advocating for our legislation, we were joined by former Fox News anchor Gretchen Carlson. Last summer, Ms. Carlson took on one of the most powerful men in media, Roger Ailes, suing him for sexual harassment. Mr. Ailes' lawyers tried to force her case into private arbitration because of an arbitration clause in her employment contract. Even worse, the arbitration clause also prohibited her from speaking out about the claims, as is the case in most employment arbitration agreements. Had Ms. Carlson chosen to sue Fox instead of directly suing Mr. Ailes, her colleagues at Fox News, many of whom were also victims of sexual harassment, would have been left in the dark about her case and may never have come forward with their own claims. And Roger Ailes' now well-documented abuse of women might well have continued. In an op-ed published shortly after she joined us on Capitol Hill to talk about her legislation, our legislation, the group of senators who met, Ms. Carlson wrote, quote, "So many women are being silenced by employers who force them into a secret star chamber proceeding called arbitration. By coercing women to remain silent about illegal behavior, the employer is able to shield abusers from true accountability and leave them in place to harass again," end quote. Judge Gorsuch, the Seventh Amendment gives us the right to a trial by jury in civil lawsuits. Would you agree that a critical aspect of a jury trial is the fact that it is usually open to the public?
Absolutely. The Seventh Amendment, I'm a big believer in the Seventh Amendment, all the amendments. And that amendment, civil jury trial, I've spoken about this a lot over the last couple of days. I believe in it. I believe in juries. I believe in the civic involvement of the people in their government. I believe in the openness and transparency of a courtroom, the ability of every person to come into it, poor or rich, mighty or meek, and have their cause heard. There are so many virtues to it. Transparency is one of them, absolutely.
I'm so glad to hear you say that, because these decisions, one 5-4 decision after another by the Roberts Court, has closed the jury to employees, and to customers, one after another. And that's why, frankly, there's so much at stake here. As Senator Whitehouse has demonstrated, what we're worried about is another 5-4 Roberts Court, making one decision after another that hurts workers, employees, that hurts consumers. And, you know, you said earlier there's no Democratic judges, there are no Republican judges. If that's the case, what was Merrick Garland about? That's what it was about. It was about, let's leave this up to the election, even though there was almost a year left. That's what this is about. And what this court has done, and listen, I'm sure there are a lot of cases decided where judges go back and forth, but there's a sort of core group of cases in which the Robert Court continually has ruled in favor of corporations and against workers and consumers. That's what this is about. And that's why this isn't, sometimes, I know I'm over my time, Mr. Chairman, and I'll just try to finish out with a thought.
Okay, go ahead.
I think I have a thought.
Maybe.
Maybe. Thank you.
Okay.
Ranking member. This is really about something. And my colleagues on the other side say, you know, that we're making something up over here. We're trying to really figure out whether we're going to see a continuation of this pro-corporate bias and of this bias toward big money and a perversion of our political system like through Citizens United, and where the weight shifts against the little guy and for the big guy. And if this election was supposed to be about the little guy, but that's my thought.
Can I, Giselle, Senator Franken, if you want another minute, you can have a minute of mine.
I want to move on.
Okay. Chairman.
Wait a minute. He gave me a minute. Ah, gee.
I want to be, when he gets done, we're going to take a 10-minute break
Thank you.
for the benefit of the nominee.
Thank you.
I know this is probably imprudent, but Senator Franken, I think you had two different thoughts. And one of them I completely agree with, to the degree that I understand the facts. And the other one I think is a non sequitur for what we're talking about. So I found a lot of what you just said now compelling. I don't know all the facts of the particular fraud case you're talking about, but I don't see exactly how that applies to what the judge is sitting in front of us being considered for today. But to the degree that, if you're right on a lot of the facts you stipulate, it sounds to me like we ought to legislate about it. And we ought to talk together about what we should do to fix this problem. I don't know what it has to do with the confirmation of a Supreme Court nominee, because I think we're talking with him about what the law is. I think a lot of your commentary was on what you think the law should be. And if your fact pattern is right, I think there's a problem there we should also fix. But I don't think it's right that when you conclude to say the Republicans are indifferent to this problem, I'm interested here not in the Republican-Democratic distinction, but in the legislative judging distinction. So we can follow up.
The problem is lawyers get paid a lot more in court than they do doing arbitration.
Thank you, sir. I would like to enter into the record. I think what just happened was one of the only non-lawyers on the Judiciary Committee just got slapped by the senior non-lawyer on the Judiciary Committee. Nebraska's going to beat Iowa in football this year, sir.
That's what you think.
I thought you were a cyclone. Anyway, I'd like to enter into the record a letter written by some of Judge Gorsuch's law students at the University of Colorado Law School. These students hold varied political views, but they all support the judge's nomination. They call him, quote, a kind and brilliant person dedicated to the rule of law and to the Constitution, close quote. They write that he was even able to make a, quote, mandatory ethics class memorable. So well done. I'd like to note one story from the letter from a law student who served as an extern. Quote, while serving as an extern, I helped him in drafting an opinion rejecting a prisoner's appeal. The prisoner had no lawyer and very weak arguments, so I turned in a draft that explained very briskly why the prisoner's claim lacked merit. The judge then asked me, where are the responses to the prisoner's arguments? Close quote. I told him that I didn't see the need to address those because they were so weak. Well, that didn't go over well with the judge. Judge Gorsuch responded, we owe this man the kindness of stating his arguments as fairly as we can and then responding with clear answers in plain English. We owe him the kindness of explaining to him in a way that he can understand why he lost the case. Ruling against this man doesn't relieve us of our obligation to show him that kindness, close quote. I'd like to ask that we enter that letter into the record. I'd also like to enter into the record a letter from dozens of Judge Gorsuch's Columbia University classmates in support of his nomination. Again, this is a diverse group praising the judge's character and, quote, unflagging commitment to respectful and open dialogue on campus, close quote. The alumni are united in their belief that the judge would, quote, serve our country with honor and distinction on the Supreme Court. I ask that this letter be entered into the record.
Without objection, so ordered.
Finally, I'd like to enter into the record a letter from the past president of the Colorado Trial Lawyers Association, Gordon Netzorg, in support of the judge's nomination. He has observed that the judge is, quote, completely honest and above board, a man of integrity, close quote. He also points out that the judge enjoys strong bipartisan support from the Colorado bar. I ask that this letter be entered.
Without objection, so ordered.
Judge, you said yesterday that there's a lot about this process that you don't like and that makes you uncomfortable. I would love to hear more about it, but I recognize that you probably wouldn't answer that question, that you can't and therefore won't answer. I think, as a newbie here, I think I'm one of 5 people in the U.S. Senate that's never run for anything before in my life, before getting here. I think that this Congress does not function as it should on a broad range of issues. You said yesterday that this is still the greatest deliberative body in the world. I hope that that can be true again. But humbly, there are a whole bunch of not-for-profit boards in my little town of Fremont, Nebraska that function a lot better at deliberation than the U.S. Senate does right now. Speaker Pelosi, or Leader Pelosi, is not a member of the Senate, but the U.S. Congress is a place that the American people look at. And when they see us, they don't primarily see public servants. They don't primarily see a distinction between the Article I branch, in which we serve as the legislature, versus an Article II and III branch that are supposed to check and balance one another. They don't primarily see a distinction between the House and the Senate. They primarily see political parties. And our founders didn't intend that. George Washington's farewell address spoke directly to the danger of faction. We live in an era where there's going to be even more disintermediation of public discourse through media channels as the barriers to entry get smaller and the digitization of journalism creates a world where there are going to be much more fragmented conversations. It is possible for us to just silo ourselves in a way where we create an echo chamber around ourselves so we only have to talk to and listen to people who already agree with us. The domain of shared facts is declining, and it's a really dangerous thing. And I worry about what comes next for the country. I worry about what comes next for public discourse broadly. I worry about what comes next in this institution. And I don't want to put too fine a point on it, but I think that people who've watched these hearings over the course of the last 3 days know that you should be confirmed, know that you will be confirmed, and know that comments like Leader Pelosi's, that if you are an American who drinks water or breathes air, they should be scared of you. That's absurd. And my colleagues know that it's absurd. And there is a real danger in not condemning that kind of reckless speech. as is kind of well known, I think I'm the third or fourth most conservative guy in the U.S. Senate by voting record, but I'm not particularly partisan, and I've not been bashful about speaking out against my party when my party has been reckless about facts. And I hope that some of the folks on the other side of the aisle, as we head toward a vote in this committee and then we head toward a vote on the floor in 2 weeks, will also speak out against the kind of reckless nonsense of telling the American people, who have day jobs, by the way. There are some folks who are watching on C-SPAN, and that's wonderful. There are parents and teachers in Nebraska and across the country who are using the C-SPAN hearings here as an occasion to teach their kids civics, and that's great. We need more. We need a more engaged public. But most people aren't watching these hearings, and most people are going to see some headline summary of what happened 2 weeks from now after there's a vote. And when the vote for you should be 95-0 or 95-5 or 100-0, math wasn't my strong suit. So Frank will fill me in on the difference between 1924 and 1925. When they see a final vote, if it isn't something overwhelming, if they see something that looks like Republicans voted one way and Democrats voted another way, and they have echoing in their ears the sounds of people saying that you are some sort of a shill for big business and that the American people should be scared of you, we will have in this body done something to further erode the public trust. And so I sincerely hope that my colleagues on the other side of the aisle, as they approach voting, will recognize that the audience after they vote isn't just people in their next primary who want to see a greater politicization of every question in American life, but the audience for their vote is also going to be people who 10 and 15 and 20 years from now are going to look back on this body at this time and next year and 2 and 3 years from now and say, did we work to create a bigger and broader domain of shared facts and of shared public trust? I know you won't comment on this confirmation process directly because it is fundamentally a political question, but I wonder if you might comment a little bit on how you see the interplay between Article 1 and Article 2 coming together to create a new member of the court, the highest court of Article 3. Obviously, the president nominates someone to serve on the Supreme Court, and we have the constitutional duty in the Article 1 branch of providing advice and consent. Some of us have done that, both with the last president and with this president, have given advice on the kinds of people that we think should be on the court, and we ultimately have a duty to consent or not to consent. It could be done in this committee, or it could be done exclusively on the floor in the full body. It could be done, as you mentioned, with Justice White. It could be done in 90 minutes, or it can be done over the course of 2 weeks. There are lots of ways that the Senate could organize itself. But could you help the American people understand, what do you think are the hardest questions that should rightly be being put to you and to future nominees for the court when we are doing our duty to having, after provided often private advice to the president in public about the future, and when we're deliberating about consenting or not consenting, what are the hardest questions that you think it's appropriate that this body would ask of nominees?
Senator, I'm grateful for the question, but that is one I'm going to have to respectfully decline to answer. Out of respect for the separation of powers. I just don't think it's appropriate for an Article 3 judge to be trying to tell this body how to do its business. I just don't. Of course, I have my personal thoughts. I put them over there. I'm a judge. And respectfully, I have more optimism for this country. I do. And I have more optimism for this body and for the Congress as a whole. I've seen it work. And maybe I'll just leave it there.
I hope you're proved right. I'd like to pursue something that Senator Cruz asked about a few minutes ago. There has been a presupposition behind some questions earlier today that if you believe in textualism, if you believe in originalism, if you believe that one of the core jobs of someone who sits on the bench is to understand the original public meaning, that somehow that means you're locked in time in history in 1788. Our Constitution has this glorious amendment process. Can you explain the relationship between the amendment process and originalism? Since the document does evolve in a formal, explicit, amended way, how does that relate to original public understanding?
The Constitution is a law, like any other law. It's our foundational law, and it was drafted to last. Maybe unlike certain other pieces of legislation that this body might think outdated and wish to update. That's its prerogative. The Constitution was designed to last. And it was a brilliant, brilliant document. I mean, the founders really were amazing. If you ever go to Philadelphia, you gotta go to Independence Hall and the Constitutional Center there and see how it happened. It's inspiring. And part of the wisdom of the document is the recognition, the humility that even the founders, brilliant as they were, could not anticipate what might happen 100 years, 200 years. We might hope a lot longer than that down the line. And so they recognize that ultimately it's about we the people. The people are sovereign in this country, not a king, not a class. And if the people wish to change their constitution, there's a provision, there's a way to do that. It's a government by the people and for the people. And that's the amendment process in a nutshell, Senator.
As a sitting Supreme Court justice tasked with upholding the U.S. Constitution, is it ever appropriate to cite international law? And if so, why?
I'm not going to, it's not categorically improper. There are some circumstances when it's not just proper but necessary. You're interpreting a contract with a choice of law provision that may adopt a foreign law. That's an appropriate time to look at any choice of law provision by any party in any contract. Treaties sometimes require you to look at international law by their terms. But if we're talking about interpreting the Constitution of the United States, we have our own tradition and our own history. And I don't know why we would look to the experience of other countries rather than to our own, when everybody else looks to us for all the imperfections of our rule of law. It is still the shining example in the world. That's not to say we should sweep our problems under the rug or pretend that we've solved all of the problems in our culture, in our society, in our civic discourse. But it is to say that we have our history and our Constitution. And it's by we the people. And so, as a general matter, Senator, I would say it's improper to look abroad when interpreting the Constitution, as a general matter.
How do independent agencies fit in a constitutional system of three branches?
Senator, independent agencies are in the executive branch, and there's a case called Humphrey's Executor that was decided in the 1930s that permits independent agencies to be created. By an independent agency, we mean that it's headed by usually a group of individuals who are removable only for cause, as opposed to at will.
How do you understand the term American exceptionalism?
I think that term means many things to many people, Senator, and I don't wish to get involved in politics. I've spoken as to how I see our Constitution and the brilliance of it and the reverence I hold for it. And I think I'll just leave it there, with your permission.
What role does the Declaration of Independence play in interpreting the Constitution?
The Declaration of Independence is an amazing document, right? These are men who, as Benjamin Franklin said, we either hang together or we hang separately. When they put their name to that document, it was a death warrant if they failed. That's why John Hancock is now synonymous with a signature. no one remembers who John Hancock was. But they know that that's a signature. Because he wrote his name so big and boldly.
You just said bigly. And I just won $5.
You embarrassed me in front of my nephew, and he loves it.
He's the one paying me the $5.
The Declaration of Independence, I think. Is that where we were?
I think my work here is done, but I do want to hear your answer.
Anyway, John Hancock, right? Signature. That was his death warrant. But he didn't want the king to have any ambiguity about who it was that was signing that document. He knew it was his death warrant. That's remarkable. That remarkable thing that the men and the women who fought for our freedom. With all apologies to my British wife. It is, however, not the law. The Declaration is not the law. It is a declaration of independence. The Constitution is the foundational document and the foundational law of the country, to answer your question. The Declaration, I think, certainly informs every American and should inform a judge in understanding the background of the Constitution and our laws. It's not a document that should be lightly discarded.
Thank you. I do still want to ask you some questions about the 9th and 10th Amendment, but I'll save that for future rounds as I'm at time. Thank you, Chairman.
Before you take your break, and on the issue of America being an exceptional nation, I would hope that you could consider what de Tocqueville said about America being an exceptional nation and say that without being political. Thank you very much. We'll take a 10-minute break.
The Senate Judiciary Committee taking a 10-minute break. Mazie Hirono, the junior senator from Hawaii, she'll be the last of the Democrats to ask questions this afternoon. Still to ask questions on the Democratic side, Senator Coons, Richard Blumenthal, Mazie Hirono. On the Republican side, Jeff Flake of Arizona, Mike Crapo, Tom Tillis of North Carolina, and John Kennedy of Louisiana. If they all take their 20 minutes, this should wrap up the second round at about 5 o'clock Eastern, but we may have a third round if some senators ask for it. We may get some guidance from Chuck Grassley, the chairman of the committee, when they return. So still definitely a couple of more hours of this third day of the hearing, the confirmation hearing for Judge Neil Gorsuch on the Supreme Court. The focus on the Senate side certainly this week in the U.S. Capitol. On the House side, it's the Republican health care law repeal and replace bill that's in the Rules Committee this afternoon, and that's live over on cspan.org. And it will come to the House floor. If it moves through rules tonight, will come to the House floor, scheduled to gavel in tomorrow morning at 9 o'clock Eastern. Lots of lobbying going on both on Capitol Hill and at the White House, with the Vice President and the President meeting with separate members of the Republican conference. President Trump meeting with some 12.5 members, including Lou Barletta of Pennsylvania. And our Craig Kaplan says that Congressman Barletta now a yes on that vote tomorrow. Congressman Brooks from Alabama, on the other hand, if they want to bring it up now, we'll vote it down. We are seeing a gain in the no votes. That may be because the House Freedom Caucus, which met midday today in the Capitol, announced that, at least certainly their spokeswoman, Alyssa Farah, announcing that more than 25 caucus noes on the AHCA. Keep in mind that the number that are needed to pass tomorrow would be 215 if all are present and voting. Mark Meadow, who chairs the Freedom Caucus, also tweeted out that I'm still hopeful we can change the bill. I'll continue working around the clock to do so, but I cannot support the AHCA as it stands. He had tweeted earlier, I remain a no. The bill doesn't do what we promised on bringing down premiums for Americans. And Phil Mattingly with CNN followed that with, to be clear on this, House leadership maintains the vote is happening tomorrow. So ahead of that, again, the Rules Committee meeting at this hour, and has met throughout the day. You can follow that online at cspan.org. And the House set to gavel in tomorrow morning at 9 o'clock Eastern, with our live coverage on C-SPAN and cspan.org as well. Judiciary Committee taking a short break. The chairman and ranking members still there. And we want to remind you, too, that they will continue tomorrow as well. One more day of the hearing for Judge Gorsuch. He won't be in the room tomorrow. They'll be hearing from folks opposed and supporting his nomination. So tomorrow should be the fourth and final day. Dianne Feinstein on the left is the ranking Democrat. Chuck Grassley on the right, the chairman of the Senate Judiciary Committee. This is the third day of the confirmation hearing for Neil Gorsuch of the U.S. Circuit Court for the Third Circuit, appointed in 2006, now nominated by President Trump to fill the 9th seat on the Supreme Court. Second day of questions for him. They should resume shortly.
Well, I mean, Yeah.